Uh, okay, well, we can, I guess, get things basically kicked off. Thanks, Stephen. Sorry about the mix-up. And well, Dr. Stephen Colby of Rimon Law is an attorney with a focus on intellectual property, patents, and technology. He's got a PhD specializing in the design of scientific instruments, a JD, Juris Doctor. We're lucky to have him. Today, I think we're going to be getting some basic IP education, which I think most of us, including me, can use. Importantly, how to avoid IP mistakes. I believe we'll have some time to ask questions. And if you're, when I went to see a career counselor 20 years ago, I talked to him for a while and he said, you're an inventor. So if you're an AGIer, you're probably an inventor. Some of us are secretive about our invention. Some of us don't care. Most of us are somewhere in the middle. So that's my introduction, Stephen.
Great. Thank you very much. So I apologize for you, everybody waiting. I did have the link and all this set up for 2 o'clock today, so I'm not sure why that didn't quite sync. And I was literally on my way to go and prep for this, but fortunately, I'm pretty good at this. I have a presentation that I'm ready to put together. And it's just bringing PowerPoint up right now. And in a minute, I'm going to share my screen. So I'm going to talk a little bit today about how to protect your intellectual property. And because this is an AI group, what I'm going to do is I'm going to talk specifically about patenting in AI. I'm going to give you some examples. Probably 70 to 80% of what I do is software related. And so a good part of it tends these days to have AI involved in somehow. All right. And let me just bring up, hold on. All right. I'm going to try to expand my slideshow. But usually I have multiple screens, which makes this easy. But we're going to go into slideshow mode here in just a second. Slideshow. Okay. Zoom. Share screen.
Looks good.
There we go. How's that? You ought to be able to all see that.
Looks great.
All right, great. Okay, so we're going to talk a little bit about things that, and my goal, I don't have a lot of time. We have like an hour or so, and I'll try to leave some time for questions. And what we're going to do is go over steps you can take to protect your intellectual property. And again, as I just said, we're going to try to do it with an AI bent. And so near the end of the talk, I'm going to give some specific examples of AI related patents that I've written, and you can see how it works. But let's just move on forward here. Let's do next. Okay. Okay, I'm not going to install updates now. Okay. The first question is, why do you want to do it? Okay. Let's imagine, my typical clients are early stage startups that are in the VC model, which means they expect to raise money and from angel investors and maybe venture capitalists, and in 5 to 8 years, maybe sell the company and be really successful and get a lot of money. So that's my typical client. For a company like that, you're usually scrambling when you first start off. You're trying to get some code written, a minimal viable product. You're desperately trying to raise money. Why would you go and spend a lot of money on IP? And the answer is valuation, right? The purpose of intellectual property, whether it's trademarks or patents or trade secrets, which are important in AI, is to get good intellectual property. And you want to make the value of your company higher. You want to do your IP development in a way that increases your valuation. This means having more money for every time you raise money, you spend equity for that money, and you want to get as much cash as possible. That's where the valuation comes in. And at the end, what you want to do is when you exit, you want to get the best price for your company as possible. And software IP and patents in particular can make a huge difference in this. I've had clients in the past that have sold for hundreds, literally hundreds of millions of dollars. And the IP made a huge difference in them getting bought versus one of their competitors. It was the IP and having earlier dates and having a really good portfolio that really contributed to I'm thinking of one client in particular in the gaming space that had a fantastic exit, $380 million. And a good part of that was because they had the better IP portfolio than the competitor. The competitor went out of business a month later. So that gives you an idea, all right? So if somebody asks you a question about IP in a pitch competition, or if an investor in a meeting asks you about IP, you want to be able to say, yes, we have some, and it really relates closely to all the reasons I've told you why my company is going to be so successful. So there's some strategy behind it, all right? All right, this is the types of IP you can get: copyright, trademark, trade secrets, and patents. Right? Copyright would cover things like actual implement the code, right? Or the layout of a user interface of a screen, for example. Trademarks would be your product, the names of your products and services, Hallelujah software, okay? That might be the name of a product, okay? Lotus 123, okay? There's a trademark name, right? Not so valuable anymore, but was really important at a time. Trade secrets can be really important. In AI, for example, the trained machine learning system is often protected as a trade secret, right? You don't give that out to people unless you really have to. It's something you want to keep secret. The weighting of every node in your system and how exactly it's structured is something you are very likely to want to keep as a trade secret. Okay, and then there's patents. We're going to talk a lot more about patents. But let me touch a little bit more on trade secrets first. Trade secrets are most valuable when you document them properly, right? It's not enough to say, well, we wanted to keep that secret, so the employee who left and took a copy with him is in trouble. Well, it makes a really big difference if you actually took steps to establish that as a trade secret. You had a trade secret program that said, these are our 10 trade secrets, and each one of them has a list of people who are allowed and who are not allowed to see it, right? So you have in your system steps, and there's certain files that are kept confidential, right, that everybody doesn't have access to, and those are the things that are trade secrets. So if you have a written program in place that has a description of what all your trade secrets are, you remind employees when they leave, these are the trade secrets you had access to. You can never tell anybody about these. In a few years from now, you can't go and use them somewhere else, right? That's how you actually make your trade secrets valuable. Sometimes you hear about people, Google and Samsung, or Google and a car company arguing over trade secrets. The biggest defense is, oh, that wasn't really a secret. Everybody knew about it. Does somebody have a question? Okay, so
Yes.
so
please mute your microphone.
Yeah. So I'm going to just plow forward through my slides, and then if you have questions, please put them. I don't see a Q&A here, but please put them in the chat. And then in the chat, I will go through the chat after I go through the slides. Okay. And again, I'm going to try to go through the slides pretty quickly. So trade secrets can be really valuable to you. You certainly have them if you're in machine learning, right? But you need to document them. And that just takes a few hours, and boom, that could be like the really valuable. I have a company right now that's in image processing, and they're really fantastic. They do image captioning, not just tagging, but a sentence description of what the image is. Their trade secret is their trained machine learning systems. They have 750 high quality images, 750 million high quality images they use for training. So they have a really robust and one of the best systems out there. And it'll run on an endpoint, it'll run on a phone. So that is their trade secret, okay? Patents can be really important. And we'll talk about patents. And I'm really looking forward to getting to the end here. I'm going to go into detail on some cases where I want to show you exactly how we approach patenting in AI. Because as you might guess, it's rare that we patent the machine, the engine itself, right? Because a lot of that's off the shelf and people have developed it. And once developed, things are, everybody's using it, right? That's not the patentable part, but we'll get to that in a minute. Okay, moving on. Okay, let's talk about what there is in patents. There's 3 types of patents you're likely to see, all right? Provisional patent applications, okay? Non-provisional patent applications, which turn into utility patents, okay? The non-provisional application is what actually turns into a US patent, right? A design patent is not very common in AI. It might be used, for instance, for a user interface, but copyright's probably better. Design patents are meant for ornamental features. For example, the tread on a tire or the shape of a hubcap, right? The cool looking spoked hubcap in your nice car, that might be covered by a design patent, right? Not so common in software, right? The provisional application has a lot of advantages and disadvantages to it. It is something that is relatively informal. In other words, I can take a design document or a white paper, right? Or a pitch deck and a design document and a white paper all together and stick a cover letter on it and file that as a provisional application. The purpose of the provisional application is to get a stake in the ground, to get a filing date for whatever material it is that we've included, right? It's quick and easy. It's inexpensive, all right? It's nice if you're about to give a presentation, if you're about to go out and publish a paper, right? Or if you're about to do accept an IEEE award on your technology, right? Or if you're about to present to investors, it's nice to file first, because in most of the world, you have to file before you make a public disclosure. In the US, you have a 1-year grace period, but generally it's a better idea to file something before you do a public disclosure. So if you're going to give a lecture, like an hour-long lecture, file your lecture slides and notes, okay? The disadvantages of the provisional is it's very often, because it's informal, it's not really complete, right? A set of lecture notes is not going to have everything you would want to have in it in order to make a full patent application, right? So while it's good to establish filing dates, the weakness of provisional applications is they're usually not as meaty as a full patent application. For example, somebody might file 10 to 15 pages of notes as a provisional, and a non-provisional application is going to be 30 or 40, carefully written pages. So something's missing, all right? The provisional doesn't provide, typically, the provisional doesn't have everything you'd want to say in it, right? Because you've done it quick and dirty, okay? Provisionals only last for 1 year. Within that year, you have to file a non-provisional patent application. This means a full patent application, typically written by a patent attorney, okay? So it's much more expensive because you've hired an expensive attorney to write 30 or 40 pages of description, okay? It's the non-provisional application that actually turns into a patent, right? And that should last roughly 20 years from the filing of the provisional patent application. And that is, patents are country specific, right? So if you file a non-provisional application in the US, that's for a US patent, okay? If you want protection in Europe or other parts of the world, you have to file separate filings in different places in the world, okay? It has the same 1-year deadline. In other words, 1 year after provisional filing, you have to decide if you're going to file in the US or in foreign applications as well, right? So those are the applications, all right? Provisional, the temporary placeholder, okay? It's really good for startups, especially startups that change direction, because you know how it is. You might work on something for 4 months and then decide, oh no, we really want to go in a different direction, okay? So my camera's a little laggy there, but anyway, I'm waving off in a different direction. So a provisional, if you've only spent a couple $1,000s on the provisional, that's great because you don't feel a lot of pain switching direction. If you spend $18,000 to $20,000 on a non-provisional and 6 months later you decide that's worthless, it's kind of a little bit more painful, right? Okay, moving on. Push the right button. Okay, we talked a little bit about this. There's something called a PCT application, and the PCT application is called a patent, stands for Patent Cooperation Treaty. And this is basically something that gives you another 18 months to decide which specific countries you want to go into. All right. And so hopefully your budgets are better. You might decide, again, a US patent is not usually enforceable in Canada, okay, or in Germany or in Korea. So you, at some point in your business, will have to decide which countries is it that we want to go for, right? Do we want, where's our biggest competitors? Okay, do we expect to be bought by Samsung or Hitachi or Toyota, right? Well, if so, then you might want to be considering South Korea or Japan, okay? Is Siemens going to be our purchaser? Well, then you want to be in Europe, all right? So you have to think ahead. You can put off these costs. It's expensive, right? The life of a patent in Europe is going to cost tens of thousands of dollars over a few years, okay? So you won't file everywhere. The only people who file in lots and lots of countries are pharmaceutical companies. And they will then file in Malaysia and in South Africa and in Australia and in Canada and all these other different places, right? So your patent attorney will talk to you about when the time comes. You don't have to worry about this for a year, okay, after your first file. But keep in mind that patents are country specific. Even if you file with the European Patent Office, you will get your patent application exam at the EPO, but then you'll have to say, oh, I want France, the UK, Switzerland, and Germany, or whatever, the Netherlands. Then you'll pick individual countries, and at the end, you'll finally get a patent in each of those countries, right? Okay. When do you want to do this? Start early, right? A lot of clients come to me before they even have talked to investors, right? It's nice to do a little provisional filing, because what happens is the investor says to his friend, I saw a company doing this. You have one just like this, right? They're doing it in the same space, and they go out and do their due diligence and talk with people, right? So it is helpful to start, and makes you feel more comfortable if you can get some really early initial filings done, right? And you may do several of those over your first year as you do development. I want to give a little comment about what's public and what's not. So if you do what really matters is there an expectation of confidentiality, right? If you present to a venture capitalist, they will talk, right? There's not an expectation of confidentiality unless you've signed a specific agreement, which they won't do until you're near the very end of your due diligence process. If you're doing a presentation at where anybody can come, at a pitch event, that's definitely a public event, right? And for software, there's a catch here that you should be aware of. If you're showing something at a trade show that's on your phone, here's my great art generation software. I've got this beautiful thing that does great art. I just typed in a few sentences and it does all this. It actually does video for me automatically. You're showing them on your phone, right? There's a server somewhere else that's doing all the heavy lifting, okay? That counts as a public disclosure of everything, right? Because the effect of what the server is doing is shown on your phone, okay? So that will count towards you, and that public disclosure in some countries, right, will be used as priority and prevent you from getting a patent there. So keep in mind that even though there might be some secret sauce in the back room, which nobody sees, that still counts as a public disclosure. So I'm going to give you a little history on this. This is funny. This law about what is and what is not public disclosure, it comes from the 1800s. There was a guy who invented a corset for his wife with whale bones in it, right? And she went out and tested it, like walked the streets of New York or so on with a corset, wearing this corset. And of course, she had tons of garments over at top of it, right, with big dresses and so on. You couldn't at all see the corset, but you could see the effect of the corset on her shape, right? And so the Supreme Court said that was a public use of the entire corset, and so that counted as public use and prevented the guy from getting his patent. So that applies today to your fancy AI software. Okay, things come back to haunt us. Okay, we're going to talk a little bit about costs. So I work in, I'm based in Tahoe, and I work in Silicon Valley. Sometimes most of my clients are VC type companies, that want to get money and grow really fast. So I'm putting numbers out here that's kind of typical for me. You'll find it varies quite a bit. It's kind of like buying a car. You can buy a Yugo, you can buy a Jaguar, both of which will spend a lot of time in the shop. You can buy a Toyota and get a much better deal, right? At an intermediate cost. So a provisional application you can do yourself. There's books on it. There's a good book called Patent Pending in 24 Hours by Nolo Press. That's about 40 bucks. You can work with an attorney. So I will work with startups, and we will put together some claims and then some drawings and an outline, and I'll read their drafts. Plan to spend 5 or 6 hours with them getting this application on file. Okay, so that gives you a provisional application that's a little meatier, that we know at least has enough to support some claims in it, right? And claims are an important part of the patent. It's the part that defines what you really own. Okay, after filing a provisional, let's say you spend $2,500 on a provisional. You work with an attorney. It costs you about $2,500. A year later, you're going to spend $18,000 to $20,000 on a full patent application. It's going to be a complete rewrite, typically, and it's going to be a substantial document written by an expensive attorney. So you can expect, including all the filing fees, to spend 10 to 20 grand a year after your first filing. Hopefully, in that time, you have done a bunch of fundraising, right? But for a typical startup, after they raise their first $500,000 or $1 million, I see people budgeting maybe 35 to 50,000 of that in IP. And it really depends. The numbers depend on how aggressive they want to be, kind of what space they're in. Are they really inventing a lot or not? Where the value in their company is going to be. Is it worth spending that much money on IP? Right? The 18,000 number on the screen here, that represents getting your application on file. Things are almost always 95% of the time rejected starting off. And so you will then have to argue with the patent office why you should get a patent. And there are things called office actions where the patent office sends you reasons why they think you shouldn't, and your patent attorney and you argue, then prepare a document arguing back, responding to the office action, saying why. And there, for a typical patent at the US Patent Office, that happens about 2 times. Okay, and they cost about $5,000 a piece. So it wouldn't be surprising that 3 or 4 years later, you've spent $30,000 getting your first patent. That's typical, right? That's a typical cost. There are patent agents that live in Minnesota. They can do it for less. But again, it's very much typically a case of you get what you pay for in a lot of cases. All right. So patents, there's 2 lines here. There's a dark red one, there's a pink one. Right? The pink one refers to patent families. So after you do your first patent application, that application can have daughters and grandchildren, right? Granddaughters. And you can develop a whole family of patents and patent applications off your initial filings, which means that you don't have to redo that work, right? The next patent application may be your same document as your first one plus 10 more pages, which is a lot less expensive. So as you develop a family of applications, you're going to find that the cost goes way down, right? So for my clients, when they've developed, a dozen patent applications, by that point, they're probably averaging close to $9,000 to $10,000 each, right? Because we're reusing material and only having to write about the additional improvements. Okay, so as time goes on and you have more applications, you find that it's less expensive. As a startup, you want to make sure your first applications are really good. And this changes, like if you're AMD or Intel or Google, right? They file thousands of patent applications. They go to people who can do this, will do a thin, they do quantity over quality, okay? They might spend 10 grand or 12 grand a patent, right? Instead of 18, because they want, they have so much stuff, right? They just want to fill the space with patents, and they don't really care about making sure the first ones are really of high quality. They'd rather quantity over quality, right? So when a business gets really big, okay, so that change will definitely happen, right? But for startups, it's really important to get the initial IP done right. Okay, well, let's talk a little bit about one of the big issues here. Ownership. And I don't know my next slide. Hold on, let me see. Okay, yeah, ownership. Ownership initially in the US vests in the inventors. Okay, that could be the founders, it could be engineers, it could be a sales guy that has ideas, right? The example I like to give is Adobe Forms, right? We all use PDF, and PDF Forms is a really useful thing, right? That was invented by a sales guy at Adobe, not by an engineer. Okay, so because ownership of the IP, whether it's software or whether it's copyright or patents, starts off with the creator, with the inventor. You want to make sure that all your agreements, whenever possible, whether it's a founder's agreement, a consulting agreement, a contracting agreement, or an employee agreement, you want to have IP clauses in there, right? That automatically assigns the IP from the person doing the work to your company. And this includes the founders, right? When you come together as a group of founders, you're all contributing something. Some of you will agree to assign the inventions you've made that you think is going to make a great company to the company, right? So make sure that everybody has this. If you're using things like Fiverr or Upwork, there's a checkbox. And when you set up the contract, there's a little checkbox that says IP rights. You have to check that. If you don't check that, and you buy, let's say, you buy some logos from somebody in Malaysia, right? And you end up using one of those as your company logo. If you haven't checked the right box, that guy in Malaysia has the right to sell that logo to somebody else, and for somebody else to use it. So you need to make sure you own all of this stuff and pay attention to IP. All right. You want to make sure that people come in don't bring IP of their past employers. Okay, that's important. If you use open software, right? Like in AI, there's lots of this. You want to make sure that you understand really well the license agreement that goes with that. Some types of open source software require that you, in turn, make your entire product open source, right? And this happened to a former president of ours last year when they tried to release his version of Twitter, and they couldn't because they realized that they'd used a piece of open source software that was going to require them to make all of what they had open source as well, right? And they got close to being sued, and they had to pull the app, and it was 4 or 5 months later before they re-released, right? So pay attention to the open source trap. Open source can be really useful, but make sure you understand completely, maybe talk with your attorney about what the license agreement with each piece of open source that comes in, right? And you have to be aware of this, because you might have an engineer that says, oh, I know how I can do this. There's this, I grabbed this off GitHub, or some great source of code, right? And you also have to worry about the security of that, right? So be careful. There is a formal assignment process. So when an patent application is filed, there will be an assignment document that's generated by, even though you have in your agreements language that requires an employee to assign to the company, you still want an actual assignment document where they sign and it lists the specific application number, right? And that gets recorded with the patent office, just like buying and selling a house. It is a recording system, and you'll want to use, you have to use this recording process to make sure you own the property. And someday, when somebody comes along and wants to buy your company for a lot of money, their attorneys are going to go look at the recording process and make sure all these assignments are done. And if there's one missing, it's going to cause a problem. I have seen cases where a company has raised $10 million, they have 40 employees, and they realize that their initial CTO didn't sign the right pieces of document. He never signed any agreements, right? He just put it off, got away with it, right? And that killed the company. I mean, right? Dead on arrival. They contacted the guy and he says, yes, I will sign it, but I want 40% of everything across the board. The investor is like, no, we're walking. Everybody walked. It was a just crash and burn situation. Okay. So you want to make sure that doesn't happen. When your patent attorney sends you assignments, make sure they get done. Make sure everybody has an agreement, some sort of agreement that causes them to assign stuff, including the founder. All right. That's ownership strategy. Okay. So I spent most of the 90s as a CTO of a scientific instrument company. And so in my heart, I am still a product guy through and through, right? I love trade shows. That's kind of my thing. I still go to them. I'm going to CES in January. It's going to be a lot of fun. Your patents, again, are there to create value for the company. In order to do that, they have to be related to the things that really make the company value. So let me give an example. Imagine you're pitching a group of investors at a pitch competition, and you are telling those investors there's three things, three silver bullets, right? One, two, three, that are going to make you a unicorn. They're going to make your company really successful that nobody else has, that the whole marketplace is desperately needing, right? Those features, those three features, is what you're telling people are going to make you successful. Those are what you want your patents about. The technology that supports those features, the product-driven patent strategy is what you want. This is a top-down approach, right? You say, okay, what is it that's going to make us really successful? What are those things? What ways can we get IP on those various things, all right? So that's a top-down patent strategy. Bottom up, which you do as well, is when engineering comes along and says, oh my God, we just came up with this great new way of doing something. It's fantastic. We've come up with this idea, blah, 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 right? So you need to go both top down and bottom up. And you got to meet in the middle, right? So something that's really cool to engineering may get on the patent list, but it may not get high priority if it's not really key to the company's current business model, right? You might put it in a provisional and see what happens in a year, right? But you're not going to spend a lot of money right away getting a non-provisional. Keep the focus on valuation. And something I do with my clients when they get to be a little older, when they're doing their A round, for example, I put together a PowerPoint slide for them that has the 3 or 4 silver bullets as bubbles, okay, on the PowerPoint slide. And then it has bubbles with all their patents and patent applications around it, all right, maybe a dozen different bubbles. And then I have lines that connect them all. And the idea is to show that this silver bullet, this feature that makes the company so successful, has these 4 patents connected to it. And this one over here, this patent covers these 2 features, right? It's called a cluster map. I didn't invent it, right? And it is, the idea behind it is to convey the value of the patent portfolio to the investor and make it more than just a checkbox, okay? So we want IP to make your company more valuable. And there's actually strategies and stuff that I give my clients to say, here's how to present this to your investors, okay? Do a mapping. And if you've done your strategy well over the preceding 3 or 4 years, it comes out really well, okay? Keep that in mind, all right? Okay, do worry about other people's IP, okay? There's a split between small companies and big companies. If you're Intel, you don't want to know about other people's patents because it increases your liability for infringement, okay? So if you're an employee of Intel, they're going to say, don't go and read patents. If you're a early stage startup, you want to know about other people's IP because you're still nimble and flexible. If you see something that's a problem, you can work around it. Intel's stuck, okay? Their roadmap is pretty much in stone, out years, right? But as a nimble startup, you see something, you go, oh, we can do it a slightly different way and avoid that IP, right? Or we can buy it, we can license it. We can look at it and go, oh my God, we could do that so much better. They're missing some major point, right? And then you file something else, right? That combines that IP in your own and is even more powerful, okay? So from a startup viewpoint, I say read the literature. As a, as a former scientist, right? Go and spend time in the library. Go to Google Patents and see everything your competitors are doing. See what the principal scientists, engineers from the look for their names, search for the competitor's name, find out what they're doing, right? And it's, if nothing else, going to give you more ideas, right? Reading about other people in your area, you want to know the competitive landscape. Your investors will be unimpressed if you don't know all about your competitors. You ought to know that, right? The other thing that I want you to do is I want you to keep notes, keep records. Okay, this is again something from my science background, right? You have to, but you don't have to. In the lab, we always kept notebooks, lab notebooks, right? And when I finished my PhD, I had like a big stack of lab notebooks, right? 20. So, and these were bound notebooks that I wrote all my stuff down in, and they're still somewhere in my garage in the bottom of a filing cabinet, decades later. The good CEOs that I meet, they carry around a notebook and they flip it open, and you have a meeting with them, and they're sitting there with their pen writing stuff down. Okay. And they do that when every meeting they're in, when they're, if it's a engineering meeting or a board meeting or whatever, they keep notes, right? So I'm going to give an example of why that's so useful. For me, it's like, okay, whenever I'm at a meeting, right, and I'm not giving a lecture, I have a Word document over, and I'm typing notes about who said what in the meeting, and even if it's a network meeting, I want to know, keep records of who I met, right? I'm going to give an example here. Let's say you're having a meeting and you are doing self-driving delivery vehicles that roll around on the sidewalk, right, and deliver pizzas to people. And you have a meeting and you write down who came up with the ideas during the meetings and some new ideas. And that's great. You now have a record of what people talked about. A month later, you hire somebody new. All right. And 3 months later, that person's former employee sues you for trade secret. Right. And oh my gosh, all of a sudden you have a $500,000 lawsuit on your hands. That's assuming you win. Okay, or maybe you win for 200,000, right? You have a huge expense, big cost, right? There's a lot of trouble. Half the CEO's time is going to be spent on this in the next 6 months, right? Well, if you have notes from your meeting long before you hired this guy, all discussing about, hey, we already knew this. This was in our product plans long before he came on board, blah, blah, blah. Boom, you've just turned this litigation into maybe a $10,000 or $20,000 problem, not a $500,000 problem. Okay, keeping notes is so useful. If there's a debate about who is an inventor, you have meeting notes, right? Who talked about what? If there's a question about, did we already go over this 5 months ago? Yeah, I have it in my notes. Look, this is what we decided. Keeping notes is good in so many ways, right? So keep records. Right? Make sure employees don't bring stuff from their former employers, right? And my suggestion, my business advice is read the literature, read the notes, read what other people and your competitors are doing. Okay, how are we doing on time? All right, mistakes. Okay, the types of mistakes you can make. Ownership, right? Not owning your own IP. This is to make sure that like the things that are invented by the people you employ or the people you engage in contracts or whatever, your contractors and so on, make sure you own your own IP, okay? Number 2 is ownership, right? That's other people's IP. Make sure that other people's IP doesn't get into your products, okay? Make sure that there isn't open source software that's going to force you to make your own software public someday, right? Number 3 is don't wait too long, okay? Don't wait until you're already past your funding round and you have 50 employees before starting IP. Okay, there's something you can do for a really low budget right off at the beginning. Okay, have a strategy. You will have lots of inventions. You need to decide which ones are going to be trade secrets, those that you can keep secret, right? And that are better as trade secret. There's going to be ones where they are kind of neat from an engineering point of view, but they don't really matter to the company's business model, right? and you want to make sure you have some IP about everything that makes your company special. Okay. You need to understand the patent. Okay. The patent has a cover page with lots of information. It has a bunch of figures, drawings. It has a long description and has something called claims. Okay. The claims are what define what is really important. And I give a whole lecture. You can look on me on YouTube and you can find me. The claim, how to understand the patent. The claims describe what you think of all the stuff in the description, which could talk about lots of stuff. It's the claims that say what the patent is going to cover. Okay, what you think is yours versus somebody else's. All right. You can have a long, let's say somebody has a 60-page specification. They might use that specification for 6 or 7 different patent applications with different sets of claims addressing different inventions in that specification. You might read somebody else's patent that has a huge specification and talks about all this stuff you learned in school, like, oh my God, this is, how did they get a patent on this? Blah, blah, blah. This is crazy. Patents are stupid, right? You're reading the specification and it's all old stuff, right? Well, somewhere in there, there's a paragraph with something new in it, hopefully, right? And if you look at the claims are going to have a series of limitations in them, right? In order to get that claim, they had to show that that combination of limitations, all as a group, hadn't been done before and wasn't obvious, right? And to infringe that claim, somebody has to do every one of those elements. So a claim might have 10 elements in it, and 9 of them might be the stuff that you go, oh, this has been around. And the 10th one is, it's a silicon oxide particle between 8.2 and 10.6 nanometers, and that they're distributed in this specific pattern. Okay, that's the part that makes what they have a separate invention. Okay, right? It's not all the rest. That limitation is key to what got that claim allowed. And you need to understand, to some extent, when you read a patent, what it means. If I see a patent claim that's huge, a whole column, that might have 40 or 50 limitations in it. It's really hard to infringe that patent claim. It may, and I have people come to me, they go, I got a patent on this, it's great, everything I do is in here. And I said, well, somebody would have to work really hard and actually do everything you're doing in order to infringe this claim. It's really, really narrow. A claim that's really short, that has just like 3 or 4 limitations in it, that's really broad, okay? Maybe too broad, but it's really broad. Right? And if you look in a patent, you will see some claims that are short and some claims that are longer, right? So a good patent has a range of scope in the claims it has, okay? That's an important thing to understand. Let's move on. Okay. This is normally the end of that talk, and usually that takes about an hour, and I went through it really quickly, all right? I'm now gonna pull up, and I'm gonna move to, I'm gonna talk about 2 clients I've had in the last 5 years that did AI stuff and was kind of impressive. And I liked what they were doing. It was really good stuff. And I'm going to give some examples of how we deal with AI you can copy this or write it down. That's my actual work number. Yeah, connect with me on LinkedIn if you want. Stephen Colby, it's pretty easy to find. Let me now reshare my screen, and I'm going to go to a patent here. Dun, 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 dun. All right. Hold on, guys. Sorry. Let's go back to share screen. That one. Okay. Let's get rid of. Okay, this is an actual patent that I wrote for a client in the AI space, and we're just quickly go through it. This is a company called Giant AI Inc. All right, and the founder and inventor is Adrian, who's a great guy, and this is the first page of his issued patent, which issued this last spring. Okay, I did write this. I didn't finish it. So my name's not here, but I did write the application. So the initial stuff here is the name of the company that owns it, the assignee, right? Adrian, who is the inventor. And Adrian, some of you might know him. He's in the AI space. He was the director of vision for Stanley, winner of the Grand Challenge. Okay, let's see if now your pictures are over my, okay, here we go. All right. And this is a patent that he got, right? So his company is doing vision still, but instead of vehicles, now it's doing robotics, right? And the idea, and now let's go down. So here's a typical easy, I'm pointing, okay. There's a robotic system. It's a block diagram, common in software, right? We have different elements of logic. We have a camera, a neural network. And again, we're not patenting the neural network at this stage, right? And then we have other features. So let's go down to other figures, and I'll give you a little description of what he does. Okay, so here's a robot. So there's an issue in robotics that you can have a actuator out in the hand, and again, I'm pointing to like at element 140 there, okay? In order to do a lot of precision, it's helpful to have the actuators near the part that's moving in terms of precision of movement and control. The alternative is to have a tether, a wire, basically, right? Which means that you can have the heavy motors and all this other stuff in the base, right? As opposed to out in the end of the manipulator, where every time you add a more powerful motor, you have to have a stronger motor to move that motor, and stronger cables and stronger parts and so on. The problem with using a tendon 120 right here, this element, is that it stretches over time, right? It might be cold in the morning and a different temperature in the afternoon, and over use, it changes. So that means you'd have to recalibrate it. So what Adrian's idea is, let's use this type of robotic control system, and we're going to use cameras to help control the movement. Okay, this is a vision AI problem being applied to robotics. All right, and this is typical of, we're not going to patent, and I'm done in we're not going to patent the AI engine itself, right? We're not going to patent the neural network. We're going to patent the combination of cameras now, and we'll go in a minute. We'll go down to the claims. Let's do that, man. Yeah. So there's parts of his patent. Here's, movement compensation, perception. That's camera, right? And it goes through some processing. The camera output is used to then adjust for the movement of the robot, and there's a feedback loop. Okay, remember that feedback loop. Okay, and you want to do task. This is a flow chart. More perception. And here's the long description, right? All the description, which tells details, which is supposed to explain what the invention's about. And at the end, we have a claim. It's pretty long, but okay. So on the column 18 here, after the first paragraph, we have what is claimed is. That's the start of the claims. So this is a robotic system, including 1, 2, 3, 4, 5, 6, 7, 8, 9, about 9 main elements. A movement generation device being one, and then the tendon, right, which is a wire, cable, or gear system of some sort, right? An end activator, that's a gripping tool or soldering iron or torch or whatever the robotics being used for, a suction cup, who knows? And then the camera, and then the neural network that builds our feedback mechanism. So what's patented here is not the neural network itself, but how you're going to use the neural network, right? The idea is, hey, I can continually, even if my robot's changing by hour to hour in the functionality of the hardware of the big piece of steel there, right? By using my vision, I can go and look and get real-time feedback, which is going to actually retrain. I can put that into parts of my neural network for improving the training. I can do all kinds of great, vision controlled robotics, right? And this time it's not a car, it's actually an assembly robot, okay? So there's his first claim. In order to infringe that claim, you'd have to do everything listed there, right? claim 2 is dependent on claim 1 and adds more limitations, so on, right? So there's going to be a whole family of claims coming off of that. So the idea here is we don't, and what I see when I see AI in patent applications, it's almost always on a feedback loop, or how do you collect great data, okay? Or how do you constantly improve the situation, improve the learning? How do you do the learning process? That's usually where we see improvement. I'm going to talk about 2 other, I don't have their patents right in front of me. I have another client that I just mentioned a few minutes ago that does image processing, okay? And they have about 750 million high quality images. So that company, their AI was on deciding how to process the image. And in their early days, they had people in the Philippines, okay, in a big warehouse with computer keyboards in front of them that would look at the images and type in a caption, right? And there was a feedback loop where you would use AI to decide what's the odds that the machine itself is going to be able to do a good job on tagging this image, right? Or should I send it to a person? So there was this decision process, which they filed patents all about, right? Ranking the image, then deciding where it's going to go and getting the data back. And then all of a sudden you've got high quality data, which you can use because a human has now tagged that image. You can use that data now to retrain more and more of your system. So they had a feedback loop, right? It got to the point where the machine system was now they don't use people anymore, right? After a few years of this, they are able to do and the other big advantage that that company did is they moved from servers to having the processing done on a phone, right? On the endpoint, on the IoT device. So they can do analysis. Is that a gun in somebody's hand on a security camera in a liquor store, and not be constantly sending video from the liquor store back to the security center? Okay, so that's the advantage they built. They started, and again, their IP kind of reflects this whole pathway that they built. They started with, okay, we're going to go either human analysis or machine. We're going to train the machine to get better and better, and then we're going to improve our model, okay, our image processing model to the point where we can fit it on an endpoint device, and that's where the company is now, right? So that's another example of the patents were not about the neural network itself. They were about how you get better data and how you constantly improve it and how you get good feedback, right? And so the last thing I'm going to talk about is another client that was I was very impressed with the way they were doing. They're gone now, but they were gathering data. And this client was called New Sun Technologies. It's gone. What they did is they were in the healthcare space, in things like a senior care, and they wanted to put either radar units in people's homes or cameras, right? And they would monitor people's activities and try to make sure they were trying to supplement home health care, right? And so they were going to look at images or movement patterns of of people around their houses. You can with radar in indoor radar, you can even look at people's breathing rates, right? You can detect the rise and fall of somebody's chest while they're watching television, okay? You would detect things like how often did they go to the bathroom at night, okay? So the question with a company like this, how do you get good data? How do you train for this? So they developed an application on an iPad that was given to home care people, the home care service people. And that was really great for them because they provided a product for managing the home care, right? Checking in and keeping the logs, and did this person eat their food? You know, all that paperwork that used to be in a piece of paper, they developed a software app for that. So the home care person would get that software app on an iPad, and they would walk into the client's home and maybe make breakfast for them or do the laundry or whatever other things the home care person do. But they would also manage the checklist on the iPad, and they would ask them questions like, how did you sleep last night? I see you got up and went to the bathroom 5 times, right? And it could be that there was a party next door, or it could be that the person has a urinary tract infection, right? So you get then an answer from the patient, okay? And the goal of the company was, okay, we are now going to have this feedback process where we're going to see movement data, activity data of the patient. We're going to then have a human in the loop, right? Sound familiar, like the last company? We have a human in the loop that's going to be in a software that's going to suggest questions to ask these people, right? And that's a feedback system that's going to let us figure out how to develop better and better data, right? Which we can then use to retrain the system and find a path to something that's really practical that leads to the point where the monitoring system is actually really contributing to people's healthcare. All right. So that's the third example of, of the last 10 years, of my favorite AI companies, of how they were using, not the machine learning module, but modeling around that, either in feedback loops or data acquisition or all these other different things. All right. Okay. So I am going to remove this window, which should stop share. And I'm going to go to the chat.
Thanks, Stephen. It was really interesting. Yeah.
I'm sorry to make everybody wait again, but I did
Well,
have this. It's on my calendar at 2 o'clock, and I was literally going on Sunday at 2 o'clock.
I'm
Okay.
taking responsibility for that.
All right. Okay. What's the cost of a worldwide non-provisional patent, including lawsuits to defend the patent? Okay, let me talk. So I'm a patent prosecutor, which means I write patents and I get them to the patent office. That's different than a patent litigator, right? Who's a litigation attorney. So I have one litigation case now, and next week is the 6th anniversary of that patent litigation. Okay. The budget for this case is about $2.5 million. It's been dragged on. COVID didn't help, all right? And I'm the technical guy, right? I'm the guy the reason I'm involved is I really can analyze the technology and so on. Right? I'm not a litigator. But patent enforcement costs millions, right? So if you're giving a pitch to investors and one of them says, well, what are you going to do about competition? Don't give the answer, oh, we have a provisional file, because that's not going to be a patent for years, and it's going to cost millions to enforce, right? If you're a company and I've seen companies do this. When I first in 2000, when I went from being a CTO to being work for a law firm, there was a case going on at the firm that involved the people who invented buffering in video, right? Which we all now use, right? And they had spent months talking with Microsoft, and Microsoft was going to buy them for millions, 50 million. It was going to be a great exit. And one day Microsoft just ghosted them, went silent. 2 weeks later, came out with their own competing product. Okay, that company went from 40 people or whatever down to 2, and they became a patent enforcement company. And they won, right? They won in court. They beat Microsoft and Apple. And everybody else Google came along and paid them royalties, and that was good. But their exit as a company would have been much better. Okay, they were destined to be much more successful than doing a litigation route. So you don't want to go into the purpose of your patents is to be valuable, not to litigate. A rough estimate, each country you want to get patents in is going to cost you 40 or 50 grand over the life of the patent. Every country has these annuities you have to pay every year, right? So, those are like $800 to $1,000, right, per country. Some are less, but yeah, it's really expensive. So you will look at where are your major markets, where your competitors are, and where your potential acquirers are. And it's really unusual to do more than half a dozen countries, right? And there has to be some special reason, because it just becomes prohibitively cost. If IP can be enforceable in China, right? Especially if you're a U.S. company and you have a patent in China and you sue another U.S. company, believe me, you will create panic. Okay, those can be useful. You might be acquired by a company that is based in China someday, right? India depends on the product. You know, if it's a device used in automotive engineering, I'm going to say it's probably hard to enforce, right? Because somebody will open up a garage and use it. You'll never be able to track them down. If it's an important medical system, like a big improvement to ultrasound, um, then yeah, that might be more enforceable. It depends a little bit on the product and enforceability, right? So, yeah, it is expensive. So you'll end up focusing on the things that are important to your company and your investors. Next question. If I don't convert the provisional, what happens to the IP? It goes away as if it was never filed. If you have a provisional application and you don't convert, then it's as if you never filed it. It stays secret, okay, which is nice sometimes. But you can no longer claim credit for it. You can't use it. If you want to, the next question is from Lance. If you want to demo an app to investor without public disclosure, most investors won't sign NDAs, except at the very end when they're about to write a check, maybe. And there's a big reason for that, is because they see hundreds or thousands of deals of companies every year, and so many of them are similar. Believe me, I've had a client, and then years later saw somebody do pitch exactly the same thing, and I'm going, no, I know exactly why that didn't work. So, yeah. So for investors, just file first. That's the best strategy. Even if it's just your slide deck. Okay.
Okay.
Now I got more messages. I'm going to scroll down. Okay. Is it best to demo to investor? Yeah. So demo, file a provisional, even if you just do it yourself. File something, and you know, if it's the filing fee is either going to be $75 or $150, depending on your circumstances. You will be able to make, yeah, that's worth it. Even it's a slide deck and design notes, right? Take the design notes and the slide deck, put the cover sheet on it, and file it. Right? The next question is, why are patents granted to parties who do not implement them in a product, thereby preventing public parties who are able to implement them from effectively doing something? You know, it's a good example. Like IBM used to I don't know if they still do this. They used to have a publication journal where they would just publish ideas to make it so other people couldn't patent them, right? I have about 3 dozen patents of my own, and I have produced products over the years, but most of those have not been products, believe me. But a lot of them I couldn't afford to bring a product. I mean, I have a product now in point of sale systems, right? And I can tell you about it. It's RF device that you would attach to clothing or a product. And when you take the device off, it changes what the RFID, there's a little switch in there that changes what the RFID tag sends, so that you can actually, if somebody takes off that tag in a dressing room or in the back stock room, your system can say, hey, why was this tag taken off here, right? Send out an alert. I want to correlate what's actually happening on the cash register with the tag, right? There should be a sale for every tag that's removed, right? And I've been trying to get the company, I mean, believe me, I'm not asking a lot of money. I've been trying to get that companies that make those security systems. No, not a lot. Yeah. So more other reasons why you might grant it, because it takes years sometimes to develop a product, right? And you know, I have sold patents, so that years later, and it's not much money. I mean, a patent is issued. I had a patent a few years ago in spell check, right? And if you in Word and Google, everybody did it, right? It was something I filed in the early 2000s, okay? And 10 years later, everybody was doing it. And it's, you know, it's not like I'm going to make $1 billion. It was a very friendly discussion with a consortium that's run by Google and Facebook and Apple, and they buy patents and then kill them, right? And it was in tens of thousands. I mean, we're not talking about, retirement money, but maybe a car. But that's the kind of price. And it's not a very good business model because unless you're a patent attorney yourself, you can't afford to spend 10, 20 grand on a patent, and you need to file 30 of them, hoping that one of them actually, you have to be early enough to be before everybody else. And you have to, so the inventor strategy is not, if you're not going to make a product, it's not a good business model. People don't necessarily want to do that. Okay. I know I work with organizations that work with individual inventors, people who make kitchen devices and things like that. And they actually make product, and that organization helps them buy product. There's a good example is word lock. You might go to Staples and get this combination locks that spells a word. Okay, that came from that organization. I know that guy, right? That's a guy who got a patent and made it. And the patent isn't on the lock itself, it's on the algorithm for picking how the letters go. Okay. But that's an example of somebody who actually got a patent and made a good product and licensed it. I mean, he doesn't make product, of course. Somebody else, he sold it to somebody, he licensed somebody else who's making all the product. So, yeah, that's it. It takes a long, sometimes it's, a patent becomes valuable like 7 to 10 years after it's filed because it takes that long for everybody else to catch up. Okay. I'm going to go cruise down. In my company, we photograph every whiteboard before racing it. Yep, that's a good way. And timestamp Legos with the owner's camera. This is the guy who's talking about photographing the whiteboards. You know what I do personally, and I have used this. Okay, I have an email address, which I'm not going to tell anybody. That's my archive. It's my personal archive, and every time I need to, the Proton Mail would be a good place to do this. Right? Every time I want to archive something, I have a good scanner on my cell phone. And so if I do my taxes, or if I have some contract I just signed, or if I have some really cool ideas, and just like this whiteboard, I take a picture, I write an email, I write notes, and I send it to that email address, right? And it's a Yahoo, Google type email address that, right? It means it's not so secure. I don't really care that much, but yeah. Nobody's going to find it, right? It's not used for anything else. So yeah, keeping notes. That's the way I store. I have literally in my garage a big giant filing cabinet, but I don't put stuff in there much anymore, right? It's this fireproof cabinet as my birth certificate and my passport. Yeah, take those notes, take the pictures. That's a really good habit. Okay. Yes. The question is, would that hold up in court, this photographing? Yes, especially if you have a regular system of doing it. Right? It's the company practice. This is the normal business practice. We have 150,000 photographs that we've stored of all these whiteboards, and this was the one taken on this date. That is good evidence. That is the type of thing you can hold up in court, right? Using a third-party email makes me even further from it, because then the first inventions I made had to do with mass spectrometry, chemical instruments. So my PhD is in chemical instrument engineering. That's the field. So a lot of software, I was doing websites in the early 90s with Mosaic. A lot of firmware, we built robots, and we did data acquisition, and in the days when we wire wrapped and put boards in PCs. Okay, that was my engineering days. So I had notes, computer records back then on a university server, and that made the difference with licensing my first patent, right? The university licensed them out to some instrument companies and made a lot of money for the university. And those computer server notes in 1992, 3, made a huge difference. That really showed. Here's the code, here's where I did everything. So, okay, what are the privacy issues? You know what? I have somebody who will do that entire talk. Privacy issues impacting AI. There can be a lot, and from different reasons. AI cameras really can be pretty scary. Um, what about your own private data? You know, Facebook uses your pictures to train face recognition and identify your friends, right? And that technology is not going to stay with Facebook. So I don't, almost never post on Facebook. Okay, I have an account, but I almost never post. I certainly don't post pictures of my kids. So yeah, don't put yourself out there. And it is a problem. I think that automated image recognition and camera being everywhere is going to be a problem. It's also, okay, privacy of your training data. Right now in the AI space, I have a company that's doing ultrasound for early premature birth detection. Really successful. Okay. I have a client that's doing ultrasound for IVF. I'm not ultrasound, but it's doing AI-based IVF, in vitro fertilization. Very successful. They can double the success of a fertilization round, which costs a lot of, nearly $100,000. So, again, now this is medical data, and you're talking about the successful cases are going to be used for training, which isn't so much a concern to me. But there's going to be a lot of AI stuff where, I don't know. I don't have a good answer to that question. Okay, my company is selling a replacement for deep learning. It is a fruit of different tree. Can you predict what would happen? We had a cloud server, but everything is trade secret. Yeah. So, yeah, you are very likely to provide it as a cloud. I mean, this is a close conversation with your patent attorney about your situation. Providing it as a cloud service. So the company I just talked about that's doing artificial ultrasound and AI for predicting premature birth, they will be initially a cloud service, right? Somebody will upload the ultrasound images and then get results. Eventually, they will be bought by somebody like Siemens or Varian, right? People who make these ultrasound machines, right? That's going to be their exit probably. Then it'll be put in every individual machine on a chip, okay? So we'll see. Your strategy will change over time, but yeah, keeping things secret is a really vital. Certainly, the details of a trained machine learning system, a trained neural network. It's not likely to be patentable, the training itself, and your coefficients are yours, right? You want to keep it that way. But make sure that you write down that that's a trade secret, and you limit exposure or who can get to it, right? There has to be a program. Okay. James is asking, I am interested in producing open source software to do something I'm calling Xbox modeling. The value in this AI is that data generated SX models. I want to protect the use of this data using Creative Commons. Yeah. Should you patent it?
Let's go. Let's do your thing. Get out of here. Come on, son. I said don't call me son.
Gentlemen, okay. The Xbox, I'd have to look more at that in detail. It is possible that you will patent the generate some part of it. The question is, where is your exit? Do you want the whole system to be bought by somebody who's going to really make it big? Do you have kids who you want to pay for their colleges? So yeah, I'd have to look at the model in detail. There's lots of other ways to, just keeping it secret works, right? But once you use it in a year, you have no option of patenting anymore. So if you're going to keep it secret, you're going to do that forever, right? Basically. Yeah. So one possibility would be go ahead and use it publicly, knowing that you're not going to get a patent in Europe or Asia. And then in 10 months, figure out, then you can decide if you want to go into the US. Right? You can file a provisional within the year of the first public use. That's one approach you can take. Again, I'd have to see the details of the specific situation. If you can divide it up, that's great. If you file some provisionals that don't cost a lot of money, again, that puts off you having to make the decision. And in business, anytime you can put off costs or having to make critical decisions, that gives you an advantage. Somebody said he filed a provisional and it was 50. So that was maybe a while ago. If you're a micro entity now, it's $75, and a small entity is 150, and a regular big company is 150, is 300. The Hedy Lamarr story, yes. Hedy Lamarr was great in lots of ways. My question is, I want to use a store of data called Concept Next, which is Cheryl, like, I don't know what counts. I'd have to look at this specific.
Yeah, that's my question. It basically, you can use it, but if you remix the data, then you're supposed to release your database, basically.
The new data.
Yeah, the new data, but it's not clear to me what they mean by remix. And if I use some of that data inside, say, for example, proprietary data, you can't just release the proprietary data. So I think I'm not sure if I can use this.
Yeah, you may not. You probably have to sit down with an attorney and look exactly what they're.
Okay, I've got one in mind.
Yeah, that's fine. Yeah, no, this is a question. This is a question.
joke.
So giving a lecture like this doesn't create a attorney-client relationship.
I know.
So you details like this that people are asking specifically for their individual situation, the facts can vary hugely, right? So yeah, it's important to decide what you're going to.
Yeah, it's a tricky. It's a short sentence, but you don't. It comes with a lot of possibilities. So.
All right. Well, folks, thank you. I see most of you have stayed. That's a good sign. Sorry again for the delay. And if you have any questions, I'm going to unshare and get my, no, wait. Oh, yeah. Anyway, I'll put my email here. Wait.
Well, thanks a lot, Stephen. That was, I would characterize it as informative, clear, useful. I was just writing some of these things down.
Now, if I'd had half an hour more to prepare, which
it's still good. I mean, improvisation, jazz, and music, it's all like so.
And it looks like the 49ers are winning.
Well, yeah, I'm going to post a video,
Sure.
so and which will include the chat too. Next month we've got Marcus Abundus. It's going to be pretty deep philosophical subject first, organization of reality, but I think this is pretty practical stuff today. We can all use it. Thanks, everybody.
Thank you very much. It's good.
Yeah, it was very, very good.
James. Yeah,
Thanks.
very interesting. Okay, goodbye.
Thanks. See you next time.